This is a railway board letter, sir, which by this letter I have been authorized to file.
Who has given the authorization letter?
Sir, this letter has been issued by railway board, sir.
Pass or no? Under what capacity they have asked you to file?
Divisional personnel officer.
10 years older, that is normally destroyed. For that sake,
And how do you meet the Right to Information Act? You are destroying the records.
My lord, please, with due submission, we can try one more chance for this.
All right, subject to payment of cost.
Yes, sir.
What is your designation?
Divisional personnel officer.
Huh?
Divisional personnel officer.
Where are the records? Inquiry report.
Sir, actually the custodian of this record is commercial department. We have written a letter to commercial department to make it available to us. But the commercial department has written that the record is very old and that's why they are unable to trace out that file. And so
Are you not?
that file is...
Are you not supervision and control of commercial department?
Yes, sir?
Are you not the supervision and control over the commercial department?
No, sir. We are personnel department. I belong to personnel department. And the DAR action is taken from the department. And that's why the dossier of the DAR, they gave the DAR of the concerned staff.
Your advocates don't know anything.
Sir?
Your standing counsel advocates, they don't know who are the competent authority, who is the disciplinary authority, who is the appellate authority. Why do you want to have such advocates on panel? They don't read and come. That is the reason matter is being adjourned from time to time. For every issue, we have to adjourn the matter. They will ask time. We don't know whether there is a non-cooperation from your side to the advocate, or he don't read and come. He can't analyze the facts. If you are not producing the records, we will allow the petition. That's all.
there is submission in that regard. But there is a letter transmitted by the Railways Ministry. Any record that is 10 years older, that is normally destroyed. For that sake,
how do you meet the Right to Information Act? You are destroying the records.
that's it. So far, there is no any existence.
No, are you not liable to? Are you not amenable to this Right to Information Act?
We are amenable to
Then how can you destroy the records?
We have our own rules and...
All right, you destroy. Then your rule is overriding the Right to Information Act.
That is that we are not overriding that act. With respect, I very humbly submit.
All right, you say that there are no records. Records have been destroyed. We'll take it. Yes, take down. Pursuant to the order dated 8/2/2023.
My lord, we are not sure as to whether the records have been destroyed, but those records are not traceable at
Then
the...
why are you mentioning?
But that there are rules. For that sake, I submitted the... I just submitted the letter that we have received from...
Sir, unless you have a concrete material, you can't make statement. You are not speaking in the market.
I apologize.
Who is the disciplinary authority? To the Madhav Mishra.
Senior Divisional Commercial Manager. Senior Divisional Commercial Manager.
Then who is the appellate authority?
Additional Divisional Railway Manager.
Last time who has given that he is a divisional railway personal officer is responsible. You have appeared, no?
Council had appeared.
Then why did you file counter? You have filed counter, no? You have filed counter. Then if you are not concerned with the matter, why did you file counter? You should have asked the concerned authority, disciplinary authority, to file counter. Who has authorized you to file counter?
Sir, this is a railway board letter, sir, which by this letter I have been authorized to file.
Who has given authorization letter?
Sir, this letter has been issued by Railway Board, sir.
Pass or no? Under what capacity they have asked you to file?
Divisional Personnel Officer.
Then before filing counter affidavit, why you did not secure records? Huh? Yes, mister.
अरे वो तो हम बोले सर
Before filing counter affidavit,
not before filing petition,
not petition, filing counter affidavit.
counter affidavit,
Huh.
we have approached the department by a through letter, and in writing they have given that the case is very old and that is why we are unable to make this available to you, and that is why the case is not submitted.
So we will record that the records are not available. Shall we record? Please take down.
My lord, please, with due submission, we can try one more chance for this.
All right, subject to payment of cost. Sufficient time has been granted to you people. Cannot utilize that.
My lord, with respect, I submit, my lord, there are many records which are quite heavy and voluminous. For that sake, my lord, cost may kindly not.
You are having wagons, no? Railway wagon. You can carry the files in the wagon.
But my lord, since the file dates back to 1995, my lord, there
You have to keep the records.
one week time may kindly be granted.
All right, we'll subject to payment of cost.
My lord,
Take down.
my lord, with respect, I am submitting, my lord. It's
All right, with respect, we are also saying that we are going to impose cost.
it's 27.
See, look at the man. He is aged about 77 years in the year 2020. Now he is 75. When are you going to settle his grievance, either this way or that way?
Only 1 week time will settle.
All right, we'll grant you subject to payment of cost. Despite our order dated 8/2/2023, the respondent railways could not produce the relevant records in order to appreciate how the alleged charge of misappropriation was proved in the departmental inquiry. To Mr. Divisional Personal Officer, Mr. So and so, Divisional Personal Officer, Samastipur Railway Division, who has filed counter affidavit, is present in the court. To he fairly submitted that before filing counter affidavit, he has been authorized, and when he approached the concerned section or a department in seeking records, at that relevant point of time itself, the concerned section / department have expressed that records are not available. At this juncture, learned counsel for the respondent seeks time to release this matter after 2 weeks for production of original records insofar as the departmental inquiry initiated and completed against the petitioner, subject to payment of cost of rupees 10,000. Cost shall be remitted in the High Court Legal Service Authority within a period of 2 weeks. For the reasons that petitioner is aged about 75 years and writ petition is of the year 2020.
There is one request, my lord. My lord, file could not be traceable. My lord, cost may kindly be removed. That matter may kindly be adjudicated. My lord, matter may kindly be adjudicated. File would not.
Take down at this stage, and counsel for the respondent railways submitted that the matter may be heard on and decided on merits. Give the dates and events. retired by him? That's on the date of
Station Master Thalwara.
station master.
Station Master. He retired on 31/8/1995.
Huh?
He retired on 31.
Died.
Retired
Retired on
31/8/1995.
1995. Then he was charge sheeted on what date?
No charge sheet, no inquiry, nothing else.
No inquiry, nothing. Then what is the punishment?
No punishment.
Then retired benefits have not been settled.
Other benefits have been made, and only the DCRG has not been paid.
Huh?
Amount the DCRG has not been paid.
DCRG not paid.
Not paid. The
Where
petitioner,
is your original application?
the petitioner,
Petitioner is a retired station master. Two stuff. He has attained age of superannuation and retired from service on 31/8/1995. Two stuff. Due to non-settlement of DCRG, he was compelled to approach Central Administrative Tribunal, Patna branch, Patna, or short CAT, in filing OA number 124 of 2009. To stop. The original application, he has sought for the following relief. Para 8 of the original application, I put a flag. Petitioner has assailed the order of the CAT dated 26/2014, passed in MA 460 of 2013, arising out of OA 124/2009 and MA 453 of 2013. Next part, the petitioner's OA 124 of 2009 was dismissed for non-prosecution on 27/3/2009. Consequently, MA 460 of 2013 was filed for restoration. So also, MA 453 of 2013 was filed for condemnation of delay in filing the restoration petition. The delay application, it is stated that petitioner had engaged a lawyer from Darbhanga bar but she did not appear on the date of hearing. The result, OA was dismissed. In this backdrop, the petitioner was not aware of dismissal of original application. Thereafter, he contacted advocate on record and came to know dismissal of original application for non-prosecution. CAT rejected the miscellaneous applications only on the score that there was no satisfactory explanation to control the delay. Further, None appeared even on 26/2/2014. Sorry, on 12/11/2013 and 26/2/2014. Accordingly, they are dismissed for default. Next paragraph. The matter could have been resolved in. Matter could have been remanded to the CAT on the score that for no default on the part of the petitioner, his application, his his MA number 460 of 2013 and MA 453 of 2013 were dismissed. So it's perusal of the records, it is evident that petitioner is aged about 77 years when the present writ petition was filed. Therefore, we are of the view that it is not a case for remanding the matter to the CAT. Next paragraph. In order to resolve the issue, the concerned authority is hereby directed to release the DCRG in order to resolve the issue and non-cooperation of the respondent in apprising this court about imposition of penalty and in not providing material relating to departmental inquiry, which was stated to be hurdle in disbursement of DCRG amount which was due to the petitioner. In the absence of any records, one cannot come to the conclusion that withholding of DCRG of the petitioner indefinitely deferred. Therefore, the concerned respondent is hereby directed to settle the petitioner's DCRG amount along with interest at the rate of 8% and settle the matter within a period of 3 months from the date of receipt of this order. So the petitioner is entitled to interest on belated settlement of DCRG in the light of Apex Court decision in the case of Vijay Mehrotra versus Union of India so and so, reported in 2007. Next paragraph. In the event of non-settlement of DCRG which is due to the petitioner along with the interest within the time limit stipulated, the petitioner is entitled to litigation cost and it is quantified at rupees 50,000 for the reasons that he had attained age of superannuation and retired from service on 31/8/1995. He has approached CAT in the year 2009. Thereafter, the present writ petition is filed in the year 2020. It is made clear that petitioner is not entitled to interest prior to 3 years of filing original application before the CAT. No, he is entitled to interest only from 3 years prior to filing of original application before CAT. That is he is entitled to interest on DCRG amount from 15/1/2006 till payment is made. In this regard, necessary calculation shall be made and disbursed. Accordingly, writ petitions are disposed of.
One request in regard to the payment of the cost of litigation. Very humbly submitted it. It's the fault of the petitioner that he challenged in
In
2020.
the event of non-settlement within
Fine.
3 months, please understand,